Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matthias Baker Mazzucci.
Welcome, everybody. Today we are talking to Jenna Glassock, who is a friend and an estate planning attorney with, let me tell you, I'm not exaggerating, a stellar reputation in this space. I mean, seriously, her name pops up. People are like, oh, I heard amazing things about her. So, Jenna, welcome back to the show.
Thank you. I'm so excited to be back.
Yeah, this is your second appearance on the show, so this is pretty good and pretty special. Today we're going to talk about a very important topic, and as we were talking right before the show, one of the things that probate is in California is that it's a public process, and that creates a lot of exposure. So one of the things that I wanted to say is that, you know, California is a dangerous state to flourish in. Okay, so let me explain what I mean by that. The more successful you become, the more exposure you have. And we all know that of all the states in the union, California is one of the most litigious one. So we have to talk about how to protect those assets. And we have to talk about why it's important and what happens. And I have plenty of stories of things that have happened so that we can sprinkle in there. But for now, one of the things that I wanted to ask you, Jenna, is when probate happens, so in the absence of planning, when probate happens, there's a death and there's a filing for probate. The question that I guess I wanted to ask you is that what becomes public when you file a probate?
So probate in 49 of the 50 states is public, but it differs state by state on what's included in those public documents. And I think that was the important point that you made, is that in California, our probate filings are particularly detailed. So we have kind of our main petition for probate, and that has to include names and contact information, so addresses and phone numbers, for any named beneficiaries, anyone who would be an heir under the law, even if they're not named as a beneficiary. So if someone dies and they have no descendants, let's say, and they have 3 siblings and they wanted everything to go to one of their siblings, then they would also have to give notice to their parents if their parents were still alive, because that would be an intestate heir, an heir who would have inherited if they had not had a will or anything, or if there's no living parents, to all siblings. And so it's possible that people are getting notice and the information is becoming public, even for people who didn't want to know about any of this. So we have to give names and contact information for all the beneficiaries, and if there's a will, for the executor. And so this comes up a lot also with parents of children, and often minor children, but even adult children, is we don't necessarily want their names and addresses being public, because there are people who look at every single one of these and reaches out to the beneficiaries or the executor or the administrator, whoever it is, to try to sell them a service or scam them or bother them in some way. So there's a lot of public contact information, personal information. And then there's also a list, not necessarily in the first filing. We do have to kind of estimate the value of the assets in the first filing, but there is a later filing in the process called an inventory and appraisal that is also public, that lists every single asset that the person owned at date of death and the date of death value of that asset. And so there are also people looking at those and saying, okay, who's about to inherit a bunch of money? Because you're also publicly declaring who's going to inherit this. So it is a lot of personal information, personal contact information, asset information, and who's inheriting what. And that's stuff that people typically don't want to be out there in the universe.
Absolutely not. Let's talk about the reasoning behind it. I mean, obviously you and I didn't make the law, but I think that we can probably speculate on the fact that there's got to be something about protecting creditors' right? If somebody passes away, they may have debt, so people may need to know that. Another thing is probably protecting beneficiary rights, like so that, you know, people are aware of what's in the estate, et cetera, et cetera. You know, I think when these laws were made, probably, I'm sure they were modified over and over, but they haven't probably been updated for the age of technology, the age where everybody can have access to all sorts of information, right? I remember in my space, I tell you something, when I first started in real estate, first of all, nobody knew about probate real estate. That wasn't even like a thing. But when it became more prominent, then services started surfacing. This is over the past like 5 or 6 years that sell probate leads to real estate agents, right? So these are actually the largest one. It's an attorney that does that. So think about it, think about it this way, you listener who is going through probate, you may experience these things. You may get the leads are sold with the information that is publicly available. So you may get 30, 40, 50 postcards or letters or everything offering all sorts of service. This is only one example that I'm talking about, which is the leads for real estate. But there's other ones like people who give you advance on the inheritance, like you talked about. You have to notify, right? And those, they don't come for free. They come at a fee. And somebody who has, a windfall event where they get to possibly inherit a lot of money, there are companies that will give you an advance. And those, while they can be helpful, they can also be predatory credit, and that's pretty not a pleasant thing, right?
I will say on the real estate side, that's the most common complaint I get from clients in probate is they'll say, wait, did you just, did something just happen? Because I just got like a ton of phone calls and emails and letters and postcards. And the problem I have with that is that a lot of time they're getting calls and emails and letters from people who are not particularly expert in probate and dealing with real estate deals in probate. And there are some really important nuances. And I've had situations, actually, one that you and I worked on together a while ago, where I recommended that they work with you. And they said, well, this other person called and offered to do it for a lower commission. So we're going to go with them. And I said, okay, like, I just want to warn you, this person, as far as I can tell, has not done a lot of work in the probate space. And, within a month or so, they were like, no, this person's terrible. And they switched and ended up working with you. And it ended up going great. But it is predatory in a way, in that it's, people are using that as a way to learn how to do something, but that's not to the benefit of my client who is, is the one who's being experimented on. So that, and then the predatory lending, I think, is a huge one.
Right. Yeah. And they get offered all sorts of services. Niche marketing has become more and more popular. So, now there's people that are selling divorce leads, and things like that. And people are getting like certified by the California Association of Realtors to do probate sales and all of that, which, by the way, the person who teaches the course by the California Association of Realtors is also the same person that sells the probate leads. Hard to believe? True. So anyway, let's move away from that because we could complain about that forever. Let's stay on your expertise. Now, everything that you talked about becomes public. Obviously, we talked about the absence of planning. Let's put a layer. Somebody comes to you and they want to start doing their planning so that they avoid this. The first step, well, I'm sure there's consultation, et cetera, but for us that to make it simple, we talk about a living trust, right? Okay, that's what avoids probate, unless it's in a corporation, et cetera. So walk me through basically the power of a living trust, why it avoids probate, and how it works.
So a living trust, I think, is easiest to understand by people who have never, ever touched this area of law or this area of doing something, right? It's kind of like a will, right? It's kind of like the way we colloquially think of a will, in that it is a document that just says who gets what when I die, who's in charge, how is it protected, what do I want to happen. It's a lot more detailed than a will for a lot of reasons, but in general, it's doing the same thing as a will. But when we put all of those wishes and all of those preferences into a trust document rather than a will document, the trust can allow our family to avoid probate after we pass away. And the big question that you raised is why, right? They're both just documents, and we wrote trust at the top of one and will at the top of another. Why does one avoid probate and the other has to go through all of this nonsense? And it really comes down to what we call funding or titling. So what we do is we create the trust. And we create the trust by talking to our clients and figuring out what they want and what they want it to look like and who's in charge and all of that. And we type that all up into our very, very, very detailed documents. And then the client signs it. And now they have a trust. And the trust has a name, right? Usually some version of their name or their last name or something like that. Right. And then the way the trust avoids probate is we retitle the assets from the person's individual name to their trust, really to them as trustee of their trust. And by doing this, it allows the client to manage their own money, spend their own money, invest their own money, really interact with the assets the same way they always have. It's not more difficult or more annoying because it's technically on behalf of the trust, but it avoids probate. And the legal fiction behind that, for anyone who's curious, is that anytime someone dies owning assets, with some very, very small exceptions, those assets have to go through the probate court process. But if those assets are not owned by the individual, but instead by the trust, then when the individual dies, they don't own any assets that need to go through probate because the trust owns them. So that is the legal fiction that allows this to work. But it really is, at the end of the day, just a document that says who gets what, when, and how, that you can change as much as you want over the course of your life, and you still interact with your assets the same way. There's just that added step of retitling, funding the assets from our personal names into our trust.
Very good. Thank you for explaining that so clearly and in details, because one of the things that people need to understand is that whether you have a will or you don't have a will, you go through probate, even if you have a will, right? Because the process of probate, I love to say this, I've said it like 100 times. If you've watched these episodes, you're just going to be bored by me saying that probate comes from the Latin probare, to prove. In fact, in Italian, we say provare, that's the word, to prove the validity of a will. That's what the probate, the origin of the probate process was. So if somebody dies intestate without a will, then it goes through probate. Or if they die with a will, testate, then it goes through probate anyway. So this trust, it's really a magic thing. Like, it's magical. Like, the trust ends up, you own the asset as a trustee of your trust. That's another thing. The vesting is very important. Now, Jenna, some people put the trust together and they don't fund it. You know, you have a trust, it's not funded. Can you briefly touch upon the Heggstad petition and actually what happens when some assets are like, maybe they were intended to be in the trust, et cetera, so we can kind of get at the nuances of that?
Yeah, so this is an incredibly common problem, is people create the trust and either they never put assets into it, or they put some assets into it and don't put others because the bank was annoying and then they forgot, or they were really good and put all their assets into it, but then life happened and they took stuff out for some reason and didn't put new stuff in, and we end up with someone who's passed away. They tried, right? They created the trust. They really wanted their family to avoid probate, and through whatever occurrences, we have some assets that are not named in the trust that we're kind of stuck with.
Right.
If those, so I want to take a step back. Anything in the trust name, avoids probate. Anything with a valid beneficiary designation avoids probate. And I want to note that because I don't want people worrying like, wait, but my retirement's in my personal name or my life insurance in my personal name. Those typically stay in your personal name, but have beneficiaries. But really, we want to make sure the real property, any business interests, checking, savings, investment accounts, that those things are titled in the trust. And if any assets are left in someone's personal name with no beneficiaries listed, those are the things that are at risk of probate. Small caveat that if we add all of that stuff up and it is under the probate threshold, which right now is $208,850, that's really easy. But if it's above that, if it's $210,000, even a little bit above that, then we do have to go to probate court. And what we originally would have had to do is open a full probate and get somebody appointed to be in charge of those assets, to then move it into the trust through the probate process. Probate's very expensive. There would have been costs in the $15,000 to $20,000 range, even with assets only around $200,000. Obviously, it gets much higher. The assets are bigger. Right. And so what happens was there was a case a while ago in California, something versus Heggstad or Heggstad versus something, where somebody said, look, yeah, but we have all this evidence that this person intended this to be an asset of their trust. We have this thing they signed or this letter they wrote or whatever it was. So court, can you just declare, can you just say, okay, we're going to count this as part of the trust? And the court said yes. They said, if we have some indicia that the person, the decedent, intended this to be a trust asset, we will just order that it is part of the trust and we don't need to go through probate on it. And so the ways we prove that up to prove that the person had intent is we show their pour over will. When you're doing a trust, you almost always have something called a pour over will that just says, anything I forgot, add it to my trust. We show a schedule of assets if there is one that lists it as an asset they intend to have in the trust. We show a general assignment if there's one that says, usually we always have our client sign one that says, all that stuff, I promise I want it in my trust, right? So that we can show that in the future if we need to. And so we still do have to go through probate court, but it's one petition, one hearing, and we don't have to do this whole long, drawn out, expensive, super, super public process. There is still going to be some public information, some notices, but it is simpler, it is quicker, and it's typically cheaper to file this thing called a Heggstad petition that just says, look at all these reasons why we can prove that the decedent meant for this to be a trust asset, for the court to then sign an order saying, I am declaring that this, and this are now assets of the trust.
Perfect. That makes sense. In my world, when I see these more happening, so if you're listening to this, this should be little antennas that are raising, is when you do a refinance for a property. If you refinance your property and then you forget to put it back in the trust, that's kind of when that thing triggers. Fortunately, with the Heggstad petition, that's pretty straightforward because look, it was in the trust. I took it out. I did the refi and then passed away. So, but I want to take a little step back as well and talk to you about something that you mentioned. You mentioned the limit, the 208,000. So something recently changed because the value of real estate was held very, very, very low in California for a long time. Where, if it was above a certain threshold, it had to go through probate. Essentially, if it was above the value of a mobile home in the middle of the desert, you had to go through probate. But things have changed. There's a new law, right? For a primary residence, we have a new threshold, right, Jenna?
Yeah. So the historical law that's actually still in the books is that, so when I said $208,850, that is a personal property. So checking, savings, investment accounts typically are what we're using that for. You cannot use that for real property. So if you had a piece of real property worth $200,000, you'd have to open a probate. The rule was you could avoid probate. You could do its own separate petition for the court to sign if the real property was less than $50,000. Yeah. And that still is on the books. So like we can actually still use that process if we have real property under $50,000. But to your point, how much real property in California is there worth less than $50,000? So it wasn't doing that much. And so in April 1st, I believe of last year, AB 2016 passed, which said that it still goes through probate, but it is a kind of a simplified probate process for primary residence only if it's worth less than $750,000. So it allows you to avoid that whole, and this doesn't have to be like you had a trust and you left it out and forgot. We would still use Heggstad for this. But if you had a will or you had no planning at all, so if you died intestate or testate, and it would have had to go through probate, but it's just your primary residence and it's just under $750,000, there is now a separate petition that would allow us to transfer that. So that's great. We can actually use that and the 208,850. So you could have bank accounts up to 208,850 and a house worth $750,000 or less. And you could actually also have another piece of real property under $50,000. So you can put all these together, although at that point, it might be cheaper and easier to just do a probate. So yeah, now we have that option as well. It is still relatively new. So I would imagine title is going to be a little iffy about these transfers for the next couple of years as they get more comfortable. Because we're not going, you mentioned at the beginning of this, one of the reasons why probate has all of that public information is to protect creditors and protect beneficiaries.
Right.
And this avoids a lot of that in a way that makes the process easier, but also kind of creates risk that we get to get rid of in a formal probate. So in a formal probate, we get to cut off creditors after a certain amount of time. And any beneficiaries that got formal notice, they have, their rights to object, but if they don't, they kind of lose those rights. We don't have those cutoff points in this shorter petition process. So it's something that I think is going to be really, really beneficial for families that own their home and the home is under that threshold and everyone gets along and it's really simple and we can do the simplified process. It's not going to be great for things where I would say like blended families or people fighting, or
Right.
the value is like really close to 750, because then, there could be arguments about valuation, lots and lots of creditors, that kind of thing. It still might not be the best option for, but there are definitely families out there who will benefit by being able to do the simplified process.
Very good. Thank you for explaining that. Now, when I start my living trust and I'm being a good boy, I did my estate planning and all of that, and I'm John Smith, but I buy the house and the vesting, so the way it shows on public records and the title, the way I'm holding title, would be John Smith, comma, trustee, right? So you're still seeing the name. Now, if I am John Smith, probably with such a common name, who cares? But if I am Marlon Brando, which I've always aspired to be, but if I am him, people are going to know that Marlon Brando owns said apartment building or said restaurant or said whatever property. So now we enter another layer, something that 99% of attorneys don't do, something that really is specific to our world. We are in LA, we serve clients that are high profile, etc. So we talk about a privacy trust. Jenna, what is a privacy trust?
So you'll see it called a privacy trust. You'll see it called a blind trust. I've heard other names for it. There's no perfect name for it, but it is at its core just a revocable living trust. The same way we have discussed everything else regarding revocable living trusts, it is just a revocable living trust. But what it does is try to account for that point that you made, is that if John Smith creates his trust and puts his house in his trust, he's taking title as John Smith, trustee of the Smith Family Trust, dated whatever date. And so his name's all over it. And so I'd say the first question I get when clients come to me and ask about a privacy trust or a blind trust is, or even when we're just doing their basic planning, and they'll see that I've named it John Smith as trustee of the John Smith Trust, they'll say, wait, can I name it something weird, right? Can I name it the rainy day trust or whatever it is? Right. And that way people won't see my name attached to my property. And the problem is then their property is going to say John Smith, trustee of the rainy day trust, and that doesn't really get us any identity protection or privacy protection. And so with a blind trust, what we do is we create the trust the same way as we always do. Who's going to get what when you die? What does that look like? We give it a unique name, rainy day trust, whatever it is. But then we need to appoint someone other than ourselves as trustee. So not infrequently, I'm the trustee. So it'll say Jenna Glassock, trustee of the rainy day trust, dated whatever date, because I have client confidentiality. I'm not telling anybody who actually created this trust. And also, there's no way anybody's going to publicly connect me. You don't want to make your brother or your spouse the trustee, because then they'll still know it's you.
It'd be easy to figure out, yeah.
But the problem, so it is really, really great in theory, and it's really, really great when it works. But it is not that simple, because one, you need to have someone who you trust to be the trustee on your trust that's not you. And so, when we're talking about front of camera people or people in Hollywood, often they'll have a business manager, someone they obviously already trust can be a really good option, but not everyone has that. The second issue that we run into is this isn't super helpful for the house that your name is already on. Because when we file the deed, in order to get the best tax treatment and all of that, we have wording we add that very clearly makes it clear that this is a transfer from somebody into their own trust. So now somebody could look and see Marlon Brando put it into Jenna Glassock, trustee of the Rainy Day Trust. Obviously Marlon Brando is the person related to the Rainy Day Trust. That doesn't get you that much. So it's much better for new purposes. The third thing I will note is that we run into a ton of issues with title escrow and the mortgage. They just don't like these. And so I have very fortunately, I can't think of any that have not eventually gone through. We've been able to work with escrow, title, and the mortgage enough to get to a point. We've had to tweak it. We've had to add trustees or remove them or change this or sign that. We've always gotten there, but I've heard stories from other people, especially there's a mortgage broker who's great, who I think you also know, who's told me that she's been in situations where she literally couldn't get the company to agree, couldn't get the mortgage company or escrow or title or whoever it was to agree. And so I would say, if you're going to do this, don't call us when you're closing in 2 days, right? do this ideally in advance before you've picked a house to buy. So that way, when you open escrow, you already have the trust in place. You can already have a copy that's with the mortgage company, with escrow, with title. You could work with the mortgage company in advance even and make sure that the pieces are in place to get this done this way, because you're going to end up in roadblocks. It's potentially going to delay escrow, which could affect the deal, right? So if there's something you're interested in, start early, I would say.
Perfect. That makes sense. And so basically what you said is do it before the purchase. Like if I already bought the house, it's probably pointless to do the transfer in the blind trust. But let me ask you about security. You brought something up, obviously a business manager, fiduciary duty, you as an attorney has fiduciary duty. But if somebody says, you know what, I'm going to put my wife's brother because nobody could trace them down to me, then they are the trustor. Am I understanding this correctly?
The trustee. So the person creating the trust is always the trustor, the grantor, the settlor, whatever you're going to call it. That's the person who creates the trust. That's whose assets it is. The trustee is the person who has full control over what to do with those assets. So if you name someone as trustee who is not super trustworthy, then they could, in theory, sell an asset, sell your house out from under you, right? There are procedures and processes in place that try to make sure there's notice to people, especially with real estate transfers. But these processes are not perfect, and this person has a lot of access and a lot of control. So yes, pick someone who you trust, absolutely, 100%, because you are giving them a lot of trust in that they're going to do things properly.
Got it. Okay, thank you. Let's switch gear a little bit. I think we covered a lot of topics, but let's talk about your practice. Let's talk about, you, since I've known you, you flourished and keep growing. And so tell me, how is it going these days? How is, first of all, share the name of your firm with us, if you wouldn't mind.
So my firm is Laurel Trust Law. We have 2 offices. I'm in Studio City in Los Angeles, and we have an office in Mission Viejo in Orange County that's run by my partner, Kelly. It's going great. It's really, I really love this area of law. And I don't need to go into my whole backstory, but I'm kind of very mission driven around this. And I love that every day we get to work with people and help them do this thing that what I find very beautiful about it is at its heart, it's incredibly altruistic, right? And most of what I do is not benefiting my clients during their lifetime. Some of it we talk about incapacity, and that's really powerful, having that planning in place for ourselves. But a lot of it is about spending our time and our money and our emotional energy now, so that our kids or whoever else we care about one day doesn't have to spend their money or their emotional energy on this, and make it easier for them. So I love what I do. And I think, and then on the post-death side is just trying to make it easier for people. A lot of the people who come to us after someone has passed away have never had any interaction with the legal system or with a lawyer before. And it's daunting and it's scary. And it's also frustrating because, as you've noted from the beginning, it's a dumb system, right? We didn't invent the system. And I know it's structured that way for a reason. But so trying to make that a little bit easier for people is also really wonderful.
That's very nice. Thank you for sharing that. I want to share something that I have learned years ago, and it always stuck with me. There was an article that talked about the most generous countries in the world who gave more money to charity, and the United States is one of the most. I don't know if people know this, but it's you do estate planning, so I guess you get to see people giving to their university, people giving to their whatever, to charity. I've sold properties. I think I've said this before on the show, that where the entire proceeds went to St. Jude Children's Hospital, millions and millions of dollars that were donated. And I think, and I guess you get to see that, right? You get to see the best part of people, where they are, when they're coming to you and they're saying, well, it's going to happen someday, I guess, unless AI is going to reverse the aging process. So we don't know. At some point, there may never be probate again, because nobody's ever going to die.
Take my job in 10 different ways.
No, but still people still need to plan for accidents. There's going to be buses driving. There's going to be self-driving buses around. If you get run over by a bus, you escape. But they call it, Jenna, escape velocity or something for the age. I don't know. It's like every year you live, if technology gets better, you gain a year of your life. And at some point, by this
Just
theory,
keeps outpacing you.
right? You live 1 year and you gain 2, 1 and 2. Okay,
Right.
we'll see about that. I better eat healthy. We gotta make good choices in life if we're gonna have these bodies where
we're making good choices. We're gonna stay around for all of the millions of kids we have between us.
Absolutely. I mean, I'm gonna have so many grandchildren. It's crazy. We're gonna start our own. Okay. Anyway, this is awesome. What else? What else would you like? Is there anything else we forgot to talk about that you want to cover, that you want to chat?
No, I would just say that I know that doing estate planning for people who have not done it before can feel very scary and overwhelming and unpleasant because nobody really wants, I mean, as much as you and I are laughing about our eventual mortality, not everybody wants to laugh about their eventual mortality. And yes. it's hard. But it really, I was talking to somebody actually about this morning, is that like, yes, our job is to kind of like sell estate plans for lack of a better term, but we're not really selling that. What we're selling is the peace of mind of, there was this thing that I have for years felt like, oh, I just have to do this and I don't want to, and it seems unpleasant. And why do I spend my money on that? I could spend it on a trip or whatever. And it's the peace of mind of, okay, it's done now. And so I guess what I would end with is I know it's not going to be, I know my meeting with me is never the most fun part of somebody's day, and working with me is never the most fun thing they've spent their money on. But
what are you talking about? You're selling yourself short. I mean, I would, I look forward to the time we spend together.
I do as well, but when my clients come to me, I'm asking them questions like, who gets your stuff when you die, which is not something people necessarily want to spend their time talking about. And so, and we get that. I totally get that. And I have kids and I have so much empathy for that. But, you know, getting it done, it's not a set it and forget it thing, but it's a set it and forget it for a little bit thing, right? And so getting it done and knowing that your family is protected from all of this probate cost and public information and all of that can be very valuable.
I wanted to end on a high note, but I'm actually going to end on a nightmare story that I want to share with you. So probate is a public process, and people have learned, I'm sorry, I know you're an attorney, but not all attorneys, just not like all real estate agents are ethical and good. You heard about the term ambulance chasers, right? The people who, those, plaintiff attorney that do personal injury and they try to pick up all these cases. Well, believe it or not, even in probate, something like that exists, especially if somebody owns rental property. So they actually will contact your tenants and try to file habitability issues and things like that. So, which is like, to me, it's like, wow, it's crazy. So yet is another reason I'm dealing with a situation like this right now. Probate passed away, a lot of rental properties. Somebody, now they know they're dead, so they are trying to sue the estate for some money and all of that. And it's all, could have been avoided with appropriate planning, because it becomes public. So there's people that, are thinking, hey, we can get a profit from this. So an admonition and an invitation to act if anybody's on the fence and protect your assets.
Good note to end on.
Yeah. Jenna, it's been such a pleasure. Thank you so much for coming back on the show. Thank you, everybody, for joining us. And Jenna, I think it's safe to say that I'm going to have you back at some point.
I was going to say, second appearance of many into the future as we age and live forever.
I love it. All right, everybody. Bye.
Thank you for listening to the Probate Realtor Show. Find more episodes and interact with us at probaterealtor.la. That's probaterealtor.la. Listen, ask questions, and get results. Don't forget to like and subscribe. The Probate Realtor Matias Baker Mazzucci is a licensed real estate broker in California, DRE number 020547763. Any legal information provided is for informational purposes only and not for the purpose of providing legal advice. Contact an attorney to obtain advice with respect to any particular legal issue or problem. We make no guarantees as to the accuracy of any information. Thank you again for listening, and we'll see you in the next episode.